Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uyamatingina. 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 Oh, uyamatingina. Yeah. So, uyamatingina.
Hello, 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 and hello again. Good afternoon to you, and welcome to another edition of the Community and the Law, brought to you by BWF Solicitors live on BWTV. Now, do you have an answer to this question? Does leave on the graduate route count towards indefinite leave to remain as a skilled worker? Some are saying yes, some are saying no. But I know definitely that will be the impetus for us to get into that discussion we're going to have this afternoon, the 31st of August, 2024. And we're going to go into that with my resource person and guest from BWF Solicitors, partner of BWF Solicitors, lawyer Eunice Echampon. My name is Oreku Fripon, and I welcome you to another edition of The Community and the Law. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you, and they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345. Or you can send a text 07950 422780. It's the community and the law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hey, it is said that for lack of knowledge, my people perish, at least quoting from the good book. And if you do not know something, the most appropriate thing to do is to ask the question. Does leave on the graduate route count towards indefinite leave to remain as a skilled worker? Yes, no, maybe so. I don't want you to double in all the guesses and then you may get them wrong. What I would want to do is to invite you to come join me on this journey known as the community and the law. And today we're discussing that very critical question, and we will be having answers to that. But before then, let me first of all introduce and welcome our resource person and guest. After we have said thank you to BWF Solicitors. BWF Solicitors are trusted partners when it comes to the law. They are located on the 4th floor of the Inner House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Fridays between 9:30 in the morning and 6 p.m. in the evening. When it comes to immigration matters, they are masters of it. When it comes to interpreting the law, they are masters of it. When it comes to filing all the issues in court and defending or even prosecuting cases, they would want to be there for you. BWF solicitors, when it comes to marriages, divorce, what you can do with those situations in your immigration situations, talk to BWF solicitors. 0208 493 7340. I say the number again, 0208 493 7340. They have an office in Ghana, so those of you in Ghana, you can call them on 055 589 5959. 055 589 5959. For emergency situations, or you want to send a text, WhatsApp message, 004477 1276 1884. 004477 1276 1884. Now, when it comes to the law, our trusted partner is BWF Solicitors. And from BWF Solicitors, we bring you lawyer Eunice Achampon. Lawyer Eunice is a partner of BWF Solicitors. And this afternoon, we're so privileged and advantaged to be having her as a resource person and guest. Lawyer, good afternoon.
Good afternoon, Quick. I hope you're doing well.
Well, by God's grace, we're doing so very well. And I believe yourself and everybody in the family is fine.
They are all doing well by God's grace.
We thank
Yes.
God. And thank you very much once again for making time for us this afternoon. We have a very important question, and I'll be putting that to you right after I've gone through the various updates we have. And once it's coming from your stable, we may be asking you to help us understand some of these things. Now, those of you who have been talking about the e visas, it's still relevant, so we want to update you on that. All BRP holders can now create the UKVI account for the e-visa. Listen, the Home Office has announced that the e-visa portal, which hitherto the 6th of August 2024 was not open, they have opened that. Applicants no longer need to wait for an emailed invitation to apply. The e-visa, let me say, that will replace the BRPs, the biometric resident cards, the passport endorsements, and vignette stickers by the end of 2024. The transition applies to all visa holders regardless of nationality or visa type. BWF solicitors can also confirm that Ghana passports can now be uploaded on the e-visa portal. So if you are in doubt, you have any challenges doing this, contact the team of immigration law specialists at BWF solicitors for advice and assistance in relation to a UK VI or the account. Now, if you have a EU pre-settled or settled status, don't worry, you already have e-visa. If you are in doubt, I'm going to ask Lawyer Ines to explain the difference between that. Who should open an e-visa account? Who does not need to do that? To help us, Lawyer Ines, what's the difference? Who needs to do that? Who doesn't need to?
So, as you have correctly stated, those who are under the EU settlement scheme, so if you have a biometric card, which is usually those who are under the EU settlement scheme, so whether it's a 5 year biometric card or an indefinite leave biometric card, you would not need to obviously apply to have your e visa because you already have that in place. You are able to share your code with an employer or any other third party. And so that is why the e visa is being created for those who have the biometric residence permit. They don't have the facility to be able to share a code or do otherwise. And so those who have the biometric residence permit or those with indefinite leave to remain in their passport, so the vignette, which is inside the passport, those are the people who would need to apply for the e visa. If you're a British national, you don't need to apply, just like those under the EU settlement scheme don't need to apply for e visa. So all those with a biometric residence permit or a passport with the vignette in there will have to apply for e-visa so that when they are traveling or when they are being employed or renting a place or otherwise, they would be able to share their immigration status with third parties who would want to know what leave they have in the UK.
So maybe two questions whilst we move on. If somebody is due for indefinite leave to remain by the 31st of December, the person puts in the application and is granted by the 31st of December. The person doesn't necessarily need to have to create an e-visa account. That's
So if you're making an application, they have already stated that you don't need to receive an email from themselves to be able to obviously create one. So
Mhm.
regardless of whether you've put an application in or you are currently with leave to remain, you still have to create that e-visa account so that when your leave to remain that you are hoping to apply for, you put in the application and then they send their response, you would be able to have that confirmation online. So they are all saying the same thing. By the 31st of December 2024, the biometric cards will no longer be issued, and therefore you need an e-visa to be able to obviously regulate your immigration status on there. And you would also have a letter that the Home Office will send. So if you are not so sure when your leave will end, the letter will state clearly that your leave will be ending on so so and so date, so that you have that in mind when you're next applying for your leave. I know a lot of people found it very easy to just look at the card and say, okay, my leave is expiring this date, so I need to make my application on this date. But it's now being put, the responsibility is being put on us to now continually check and then make sure that we make our applications before our leave expires. But if you are somebody who already has indefinite leave to remain, obviously you wouldn't need to make any further applications after any time.
There's this other situation where somebody, in the midst of or prior to the 6th of August, um, tried to create the e-visa account and has stalled, kind of. The person hasn't done it. Then, when the person was creating the account, I think, as people would say, a buddy, somebody else's account or somebody else was allowed to uh, put his or her name on there. Which of the two would have to complete the process? Is it the main applicant or the person that helped or the person that may be referred to if there was any other situation?
Okay, so I think the unique thing about this e-visa account creation is the fact that you, as the applicant or the biometric residence permit holder, is able to create the account using your own email and your own contact number. If therefore you are saying that you're not very conversant, so you need a helper, so somebody to help you create the account, you can also put in their details. So if somebody is helping you create the account, it allows you to put your details and the person's details as well. And so if the person is helping you create the account, they would firstly use your details to create the account, and then when it comes to the helper, it will now ask for their details to be put in. And so once you've completed that process, then it will take you onto your phone, where you will need to take the photograph, scan the face, and then complete the whole process. If you were not able to complete the whole process before, which was in July, prior to this month, they're saying that, of course, you can still do it. And to tell you the truth, I believe that there will still be some people who would still not be able to create the account because
Mhm.
they still haven't been able to complete the whole online process of transferring everybody onto their system. So we are hoping and praying that by December, come what may, they would have done all the transfers that they need to do, and everybody will be able to register onto the UKVI account.
Yeah. Today is the very last day of August 2024. So, if you have any difficulty, if you have any challenges, BWF has offered that we could contact them and they will help you through it. So, call them now: 0208 493 7340, 0208 493 7340. Or if you are within the Seven Sisters vicinity, just pop into the office, fourth floor of the Anna House, 214 to 218 Tottenham High Road. It's on top of the Seven Sisters train station when you use the exit number 2. So be at BWF and you get the support and the help you need. Now, moving on, this week we also had this update to give you as far as our nugget is concerned. And earlier last week, I think we mentioned this, and I want to reiterate that. Let me quickly run through this. Where a spouse or parent cannot meet the minimum income requirement, the Home Office must consider whether a refusal of the application could engage Article 8 of ECHR, because it could result in unjustifiably harsh circumstances for the applicant, their partner, or a relevant child. The Home Office is required to consider other credible and reliable sources of income or support, including third-party support for family from family and friends under Gen 3.1, 3.2. This is from the guidance Family Life as a Partner or Parent and Exceptional Circumstances created in May 2024. If you want further details of it, last week, the program that we had, I had that with Lawyer Eunice as we're doing now. You can go back onto the platform that is at BWF Solicitors Facebook, BWF Solicitors YouTube, BWTB Facebook, and YouTube, and you can watch the program full. There's a client that is also very happy about what has happened with them from BWF Solicitors. And Evelyn says that I visited BWF solicitors with an impossible immigration issue, which my friends and family can bear witness to. But BWF solicitors made it possible thanks to Lawyer Charles Asma. I really appreciate those help during the process and strongly recommend BWF solicitors to anyone with any immigration and other legal issues. That's what you get when you come to BWF solicitors. So I recommend that you get in touch with BWF solicitors Facebook, YouTube, watch the programs, watch the updates, and also visit them as well. What are you going to put in your pocket this week as we go along and enter into the new month? You can get your visa fee from outside of UK waived if you cannot afford it. Hmm. That sounds real good. And let's look at the detail and get Lawyer Eunice to give us more detail and update into that. With visa fees for partners and dependents so exorbitant, £1,972, and immigration health surcharge, 3,317. That is over £5,000 for each applicant. It is important to explore whether you qualify to have your fees waived. Listen, applicants from outside the UK will be granted a fee waiver if one, either they can credibly demonstrate that they cannot afford the fee, and or two, their income is not sufficient to meet their child's needs. Affordability here is described as when the applicant and sponsor do not have sufficient funds at their disposal after meeting the essential living needs to pay the fee. If the application is granted, the applicant would then make a fee free application. Now, Home Office published this guidance on the 16th of June 2022. Well, we didn't know. BWF, you have unveiled that. Loaines, take us through it.
Yes, so this fee waiver guidance was, as you have stated, introduced on the 16th of June 2022. And it was befitting because after the COVID, a lot of families were struggling, and there were families that needed to bring, whether it was a spouse or a child from back home. And when I say back home, I mean outside of the UK. And so this guidance made it a lot easier for them to now apply for a fee waiver and then have the fee waived in terms of the Home Office application fee and the immigration health surcharge. Um, as we have previously stated, when you're applying for something like this, there are certain evidences that they would have to look at. Nothing is given out for free. They would need to also put in their checks and then make sure that you are saying what is stated in your application form. So, um, as we have already mentioned, it's to do with your affordability. Are you able to pay it? If you are looking at the fee for one person and you are thinking, okay, I need to do an application for two children. So if I have to pay over £5,000 for each child, then that means that I'm looking at over £10,000 for two children. And that's costly. When it comes to the immigration health surcharge as well, is on the basis that you are actually coming in to join a parent. So if it's a parent who is already on leave to remain, the leave that that parent has will be calculated to obviously match the child who is coming. So if it's just 1 year left on that parent's leave, that 1 year will be granted to the child. But it's important to note that when it comes to the application fee, that has to be paid. It is only when it comes to the immigration health surcharge that they would calculate how much is left on the mothers, and then obviously apply that in terms of a child. If it's to do with a spouse, then obviously they'll be granting a 2.5 year leave, regardless of how much is left on the UK sponsors leave. And usually in that case, they don't grant it to anybody who is with leave to remain. They grant it to those who are British spouse or settled here in the UK. So with that, obviously you would have to pay the full £5,000 for the application. But when they are considering such an application, they expect that you will provide evidence that you can't afford the fee, or you are not working enough to be able to have sufficient funds to meet the essential needs of a child who may be here in the UK, and also to be able to obviously maintain or look after that child and yourself. So if you are saying that you have two children here, you're making a human rights application such that your spouse will come and join you, or that your other child who is outside of the UK will come and join you, based on your bank statements, your pay slips. Um, it could be that you'll have other evidences of people who are supporting you, such as family and friends. Based on their support, there's no way that you'll be able to afford the fee, and therefore you would want them to grant your request of a fee waiver. If they think that it is possible for you to pay part of the fee, so for instance, they can see that you have sufficient balance in your account, that's what we would call savings, then they would say, okay, why don't you pay for the application fee and then we will pay for the IHS? Or we'll pay for the application fee, you pay part of the IHS, and we'll pay the rest. And so once they have been able to assess the evidence that is handed to them, which obviously it is up to the sponsor to provide such evidence, then they will go ahead to then grant a fee waiver. If they believe that the evidence you have provided is not reliable enough, or you are trying to obviously take money from your account in for the sole purpose of obviously um, dodging, shall I say, dodging the amounts that you have to pay, then it means that they may ask you to save up for another 1 year or 2 years to be able to make the application. So it's important that if you do have monies going into your account, you should be able to um, correctly state that this is your income, and the source of your income is from employment or is from a third party, and the income that you receive is used for so and so expenses. So they want you to be able to categorically say that your expenses are for shopping, rent, um, insurance, the essential needs that you have. If obviously the money is being spent on holidays, luxurious things, then they're going to say, well, those things are not essential items. And so maybe we think you can save up some money. Also, if you, for instance, own a home and you don't pay rent, they might be looking at you maybe selling some equity in the house to be able to pay for it. So all these things will be assessed in terms of your fee waiver request. And if you have any savings anywhere and you haven't declared it, they have the right to check your accounts with whichever banks you have. And then if they find that you have not provided an account statement that you do have, they will then ask you to provide that account statement so that they can obviously look at how much you're earning. And so they don't just look at the sponsor who is here in the UK, they will also ask for the applicant who is back home to provide evidence of their savings or their account as well, in order to make the correct assessment in regards to whether they can pay the fee or not.
Okay. Well, so the assurance here is that under certain circumstances, you'll be able to get your fee waived, and you can get that for free. So if you have any further question, what I would advise is that you contact BWF solicitors 214 to 218 Tottenham High Road. Call them on 0208 493 7340. BWF Solicitors is proud to be associated with the community and the law. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you very much, BWF Solicitors, and thank you to you out there for sticking and staying. Now, if you stayed so far, I would want to salute you and say that you've benefited from the nuggets and the updates we have had. So, like the page, comment, and share as well. If you're new here, there is a forum and a classroom down in the comment section where people, when they log in, like the page, announce their presence, and also make sure that they copy the link and share with other people. So I want you to do the same. And remember to click on the subsection and the notification bell so that whenever we put any information and any content out, you would be notified so you don't miss out. But in any case, if it was that you didn't have the time to stay with us during the live broadcast, you can go back and watch it anytime. BWF Solicitors on Facebook, YouTube, BWTV, Facebook, YouTube, and you would have everything we have recorded since Adam to enjoy that. And Nanette Yahne, you're watching with us. Wimpini Adam, thank you so very much. I also have Rama, Nana Sewa, and Augustina Champon, amongst many others. Rama is saying good afternoon to you, Augustine. Good afternoon. Those of you who haven't really announced your presence, please do. On YouTube, we have Helena. Thank you, Lawyer Ines, for this important information. There's another very important bit coming up, so don't go away. Stay with us as we go into that discussion where we're looking at skilled worker route. What is that? When you come to the UK through the skilled worker route, what is expected of you? What do you do before you qualify for that? Then there's also the saying that after a certain number of years here in the UK, you can qualify for indefinite leave to remain. That apply to the graduate route as well. Ladies, now we are in your fold again. We're looking at the graduate route and the skilled worker route. Are they one and the same thing, or they are totally different things, or probably one comes under the other? What are they? Can you take us through it, please?
Yes. So When we talk about the skilled worker route, that is somebody who has come into the UK to work. So whether it be as a skilled worker on the global talent route, innovator, founder, scale up business, um, the list goes on and on because there are quite a number of work routes or categories available. So anybody who has come into the UK to apply as a skilled worker would usually be employed by an employer who has a sponsor license. And so a sponsor license is usually what the Home Office will give you as your license to be able to grant a certificate of sponsorship to somebody who is an immigrant or migrant worker. And so with that, you are able to then apply for leave to remain um, coming from outside the UK into the UK. Or if you already have valid leave to remain whilst in the UK, let's say you've completed your studies as a student and you are going on to work, your employer can grant you a certificate of sponsorship, and then you can obviously switch from the student route to the skilled worker route having completed your course. So the skilled worker route is completely separate from the graduate route. So a graduate will usually be somebody who has completed a course and maybe hasn't yet found an employer who can grant them COS. So they have completed their studies, they want to be able to remain in the UK, get a bit of their feet grounded here in the UK, and then maybe they might be able to find an employer who will be able to take them on. So, in the meantime, you can apply onto the graduate route, which gives you 2 years leave to remain to be able to obviously work and live until you find an employer who is willing to take you on as a skilled worker. Usually, those who have done a PhD would be able to have 3 years extra on the graduate route. So, you have to be able to show that you have successfully completed the course. Otherwise, you would not be able to get onto the graduate
No,
route.
so if, for instance, I come to the UK to pursue um, a graduate course for my first degree, and I complete. When I complete, do I then automatically go onto that graduate route where I would be giving a 2 year leave to remain?
So usually, if you have successfully completed, then you would have to apply to the graduate route. It doesn't come automatically. You have to apply to it, and then they would grant you your further 2 years leave to remain. They usually do their checks with the school. So if you are saying that you've successfully completed, they have to do their checks with the institution that you obviously took your course in, and then once that has been shown to be credible, you would be granted those 2 years or the 3 years as a PhD student.
So you when you apply, automatically you'll be given 2 years, or you could apply for just a year extension for you to find your feet grounded.
Usually they will grant you 2 years. So you're paying for the application and then the 2 years IHS. So once you've completed the application, you are automatically paying for that. And so you will be granted 2 years once you have been granted your leave.
So, for instance, if I completed my first degree course in July, for instance, and I have applied for an extension, they give me 2 years. It means that in 2026 June, I am able to live and find work in the UK as a legal person
Yes.
who has the right to live here.
Yes. And so, like I said, it has to be verified by the university. So, if the university says that you have successfully completed your course, then you can automatically get onto the graduate route. If you, for instance, were not able to complete the course for whatever reason, then it means that you have to now go to the university to ask for another certificate of acceptance of study. So you are not applying onto the graduate route, but then now you are looking to apply as a student who hasn't yet completed their course successfully. So the key here to the graduate route is successfully completing the
Completing the
course.
course. Right.
If you haven't successfully completed the course, you would not be granted the 2 years leave to remain.
Okay. Then within the 2 years, I'm able to find a job. When I find that job, does it mean that the employer would have to give me a certificate of sponsorship? Why don't I then just continue working because I have 2 years to remain? I have found a job and I can remain in the country. Or, as a precondition, you have to be giving a certificate of sponsorship.
So when it comes to the graduate route, there's no obligation that an employer needs to give you a certificate of sponsorship unless you are saying, I want to remain in the UK after my 2 years. So remember, the 2 years comes very quickly. Before you know it, the 2 years is up. If you want to continue to live and work in the UK, then you should be able to have valid leave to remain after the 2 years. And that is why we say that within that time, you should be able to get an employer who is able to grant you a certificate of sponsorship so that you can continue living and working. In that case, it means that you'll be switching from the graduate route onto the skilled worker route. So you are now on the route, you are working, you are living life as you should, but the 2 years will be up and you would not have further leave because there is no route to settlement on the graduate route. But in terms of you wanting to stay in the UK, you will then have to find another route. And most people who have stayed on the graduate route will usually want to continue working. And so the skilled worker route is the best option in terms of them continuing their leave in the UK. And so once you've been able to find an employer that has a sponsorship license and is able to grant you a certificate of sponsorship to work, you will then be able to use that in your application as a skilled worker and then continue living here in the UK. And of course, it goes without saying, because you're here working and living, it leads on to settlement afterwards.
Well, we'll be coming back to that detail, but let's look at a person who's completed the first degree and has found a temporary job or a fixed term contract with, say, a local authority or any government institution. Um, I'm asking that after the 2 years, if they find the person's work satisfactory and they will want to keep that person, um, who is entitled or who can apply for sponsorship? Can government organizations, government institutions, authorities, and private individuals all do that? Or the certificate of sponsorship is limited to specific jobs and employers, if I should say so?
Okay, so in terms of those who are usually granted sponsor license, um, we're talking mainly employers.
Mhm.
So, what kind of employer will be entitled to apply for a sponsor license?
Yeah.
So, if an employer is usually government based or private based, it doesn't really matter. As long as they can show that they have a specific amount of employees. It could be less than 50 employees, it could be more than 50 employees. So it depends on whether it's a small business or a large business. Once you're able to show the number of employees you have, you should be able to show your turnover, and usually it's about 5 million. So whether it's less than 5 million or more than 5 million, and then you should be able to show the income that you receive every year. And so for the businesses, it's not necessarily whether they are private or they're public. Um, any one of them can apply for a sponsor license to be able to grant people certificate of sponsorship. So it's not limited in that sense to um, public companies or limited to small companies or limited to big companies. If you do meet the criteria that I've just mentioned, and of course, if you are also regulated and you can show that you are registered with the regulatory body, then that should suffice in terms of you applying for a sponsor license. But be rest assured that the Home Office will do their due diligence and checks to be able to make sure that you will be able to follow the process through and through.
So if I finish with my degree course, for instance, and I have the skill, wherewithal, and business idea to be self-employed or create my own company, would I be considered as somebody employing somebody and be granted the certificate of sponsorship, or probably giving the leave to remain after the 2 year period?
So usually, if you are saying that you are setting up as a self-employed person and you want to be able to find out if after the 2 years you yourself can then apply for a sponsor license for yourself, obviously there's criteria that I just mentioned. You should be able to meet that criteria. So as a self-employed person, are you able to show that you are a company that is able to employ other people? Do you have a turnover of 5 million or less? What income are you receiving in the year? Obviously, if you are a self-employed person, you haven't registered as a company, so you have to bear that in mind. But they didn't say self-employed people, they said company.
Okay.
So first of all, you need to ask yourself, am I a company or a sole trader or just a self-employed person? If you're just a self-employed person, then unfortunately you don't even come into the criteria whatsoever. So if you're a company, like you're saying, and you say you're employing just yourself, then what kind of a business is it? Does it have less turnover for just you as a business? And what is the likelihood that obviously your company will be um looking at bigger turnovers and would need more employees? So if you're saying you need employees, what shows that you will need employees from outside of the UK? You need to be able to show reasons why you need employees from outside the UK. And especially if you've just started, you will need to be able to show that you have done your due diligence, and you would obviously wouldn't get enough people within the UK to come and work for your company. And that's why you need extra personnel from outside of the UK. So if you can justify those reasons, then of course the Home Office will usually grant you a sponsor license.
You mentioned that if for any reason you are not able to complete your course, you would have to go back to the educational institution, the university, the college, wherever, for them to grant you an extra acceptance to be able to do that. How many times within a certain period can I do that? Is the law allowing me for just about once of an opportunity, or I could do that as many times as the school would accept me?
So it's usually to do with the institution or the school that you've applied to. Um, Most schools may say that, hey, if you are not able to pass the course, that means that they are not getting any benefit because you don't pay any extra fees to them. And schools or institutions also exist as a business. So if they don't think they are benefiting in any way, they would usually decline granting you further CAS, CAS as we usually call it, to be able to further your studies. If you have a good institution and they are able to say, hey, okay, we know that you didn't pass the course, we are willing to give you an extra 6 months for you to pass the course. And once you pass the course, then you can go ahead and then obviously um, return back to your country or whatever it is. So it's usually based on the institution and whether they are willing to agree to grant you further certificate of acceptance of studies if you didn't complete your course, or if you weren't able to pass an exam or whatever it is. The Home Office doesn't really come into this unless you have valid leave. If you do not have valid leave, then the expectation is that you leave the UK and return when you are able to apply for valid leave to re-enter the UK.
Somebody's asking a very interesting question here. If, for instance, I complete a course and then I try to take advantage of the 2 year leave to remain after my graduation, then within 6 months, I decide to go back to school and pursue another course. Does it mean that the first opportunity that I had to enjoy that 2 year extra leave to remain is gone? And when I complete, I can take another 2 years.
So I'm not sure whether the person was able to apply to the graduate route for the 2 years and then applied using their CAS for a student
For
visa.
another to pursue another course. So the
Okay.
graduate route application that was granted, uh, does it forfeit that?
Okay, so if you obviously applied to the graduate route, you have valid leave to remain. If you then within the graduate route you applied for a CAS and you were granted a CAS and you were saying that you were studying, after your studies you can apply for another
Another
two
two
years
years.
if you successfully complete this current course. Yes.
Okay. Right. Then the obvious question will be coming back to that, but I want us to explore all the bits about the graduate route and all that. Um, a bit of a naive question. Let me put it that way. The graduate route application, is it granted automatically?
No, so you have to apply for it. You pay you pay for the application, you pay for the IHS. So you apply for it, and then they grant you your 2 years leave to remain, and you have to do it before your student visa expires.
So then, the only criteria probably I would have to meet is that the school will confirm that I've completed the course successfully.
Yes,
Oh,
yes,
okay. So it's an easy application, I guess.
yes. It's quite simple,
Oh, okay.
straightforward.
Well, if you just joined us, we're having a discussion on whether leave on the graduate route lead to indefinite leave to remain here in the UK. And we're linking the graduate route to the skilled worker route. Lawyer Eunice Echampo, partner of BWF Solicitors, is taking the time to explain the difference between the two to us. And also, we have explored several things around it to be sure of where we are. Are you a skilled worker? Are you a graduate? Are you somebody on the graduate route? Let me put it that way. How do you migrate from the graduate route to the skilled worker route? She's taking time to explain that. If you have any questions, any concerns, you can put them in the comment section down below on Facebook and YouTube, or you can send a text to us on 07399208468, 07399208468. Or you can call us if you want to speak to lawyer Eunice Champon on 0208 493 7345, 0208 493 7345. We're live on BWTV and the Community and the Law as the program. Now, later on, I remember I gave you the nugget. Okay, so the question will be coming. I have a scenario I want you to look at, and today I'm being gracious to give you a sneak preview into that, and then you think about it, and I'll ask you what the answers will be. Barbara Brown is applying to join her husband Kwekusu in the UK with two of her dependent children under 18 years old. Baba has been told that their visa fees come to 13,000 for all three of them. Kwaku is a bus driver and earns 29,000 per annum but has no savings. Kwaku tells Baba to apply a loan as they cannot afford the fees. What must Baba do to prove that she cannot afford the fees for all of them? One, she has to swear a statutory declaration, to confirm that she cannot afford the fees. Or two, Baba would have to send her tax clearance to the Home Office. Or three, show how much income she and Kweku get and how much she has in savings. Then deduct all their expenses. Well, quite technical. You're doing some mathematics here and there. 13,000, 29,000 statutory declaration, tax clearance, and expenses. Think about this. And I'm going to take a break. And when we come back, we will continue with the discussion and see what is the transition and what counts towards indefinite and the rest of it. Larry Mr. Champon is our resource person coming from BWF Solicitors, our sponsors. I want to say thank you to them. We'll be right back.
Based in London, we are a dynamic award winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We're live and back with you. BWTV bringing you the community and the law, and it's brought to you by BWF Solicitors. Does leave on the graduate route count towards indefinite leave to remain as a skilled worker? Now, we have spoken about the graduate route, we're speaking about the skilled workers. Lawyer Eunice Achampon, as I said, is our resource person. Lawyer Eunice Achampon is a partner of BWF Solicitors. Now, Eunice, we're back. Thank you for your time. Let me ask, if I am on the graduate route, I looked at a situation where I have completed a 3 year course. I apply for my graduate route. They grant me the 2 years. In between, I apply for another CAS, that is an application into another institution. I'm granted, I complete my course and do another 3 years. That makes it 6 years. We're also been told that when you spend 5 years here in the UK, you could qualify for indefinite leave to remain. So let me pick up from the graduate route end. Does it lead to indefinite?
So the answer is no. It
Okay.
would not add on to your should I say new route or new skilled worker routes that you have decided to apply onto. And that is solely because the graduate route does not lead to settlement. It's like somebody coming here on a visit visa and thinking that because they came with a visit visa, so that will be counted towards maybe a further leave to remain application that they made as a family member. Unfortunately, applying onto the graduate route doesn't lead to settlements. And so there are certain categories within the law that lead to settlement, and the skilled worker route is one of them. With the skilled worker route, they have specified that if you have continuous qualifying period of 5 years, then you are sure to apply for indefinite leave to remain after that 5 years. And that is quite different from most routes, because if you're on the family route, for instance, as a parent or as a partner, you usually have to wait for that 10-year period before you can apply for indefinite leave to remain, unless you came through the entry clearance route as a partner and you have met all the qualifications and the criteria that is necessary to be able to say that you have completed 5 years of residence and therefore you're applying for indefinite leave to remain. So, as a graduate, unfortunately, you can't count those 2 years towards the 5 years leave to
Okay.
remain as a skilled worker.
Now, you have shown us that technically you can move from the graduate route within the 2 year period that will be granted. And you can move on to the skilled worker route when somebody employs you or gives you a certificate of sponsorship. Now, for instance, I've applied for the 2 years on the graduate route. After 1 year, I get employment and I start my contract from there. Does the skilled worker route lead to indefinite? And where does it start, or where do we start counting from?
Okay, so in terms of somebody who was previously on the graduate route and has now applied onto the skilled worker route, once you have been granted leave to remain as a skilled worker, so if, for instance, I made my application this month, they granted me further leave to remain in September of 2024, my leave to remain as a skilled worker will start from September 2024. And therefore, my 5 years will be up by September 2029. So, of course, you would you would love for your 2 years to count towards this skilled
Yeah,
worker
yeah.
route, so that by 2027 you'll be able to apply for indefinite. But unfortunately, that is not the case. The immigration rules under Appendix Skilled Worker Settlement states that you should have a continuous qualifying 5 year route on the skilled worker route to be able to apply for indefinite leave to remain, and that usually includes people who are on the skilled worker route or on the global talent route or innovative
Mhm.
founder route or any of the work routes, but not the graduate route.
Can somebody then put up this argument that when I applied for the 2 years extension, I had legitimate expectation that I wanted to live in the UK and I would have spent 2 and 3 years into my current contract, and that counts up to 5 years. Can't I make that argument?
Unfortunately, you can't, because it categorically states under the immigration rules under Appendix Graduate that unfortunately this is only a graduate route for 2 or 3 years and it does not lead to settlement. So it's good to obviously read the small details, because somebody can put forward that argument very nicely and then they will just categorically state there, well, this is what we say on our government website, and that was what we have always stated, and so you should have read that before making the application.
So if you miss any detail and you put in an application, it means that you would have lost your money.
Well, they are happy to refund you your money if you are telling them that you are going to switch to make another application. So, if, for instance, you realize that, okay, I made the wrong application, I'm now going to put in an application as a skilled worker instead, they would refund that money to you because you're making a valid application on a different route.
Right. Well, if you just joined us, you can send in your questions, your comments, and your text messages through our number 07399208468. Or if you would want to pose your question directly by voice to La Eunice, you can call us on 0208 493 7345. 0208 493 7345. And Lioness is here. She will definitely give you an answer to your question. It could be about the topic that we are discussing, or it could be anything that bothers you. BWF Solicitors is gracious enough to give us answers to all our concerns. So, yes, the lines are ready and open. You can call us, or you can text 07399208468. Eunice is here. Eunice, let me also ask, on the graduate route, I know previously there were the updates that said that partners are not being allowed to be brought in here. If I'm on the graduate route, can I bring my partner, my spouse? But before then, let's see who we have on the line. Hello.
Hey,
Yes.
good afternoon.
Good afternoon, sir. Thank you for joining us. Lawyer Eunice is here and ready to take your comments. So please speak to her.
Thank you. Yeah, my name is Ben. I'm calling from Leeds.
Okay, Ben, please go ahead.
It's just I mean, one of our brothers is in difficulty, so he, yeah, COS. I wouldn't mention the company's name. I think they actually employ them from Ghana,
Mm-hmm.
IT experts to come and, but the company is an audit firm.
Okay.
So last week, he received a letter to say they are terminating his appointment. Been here for only a year and a half now. We are uncertain as to what to do.
Did they say why they terminated the appointment? Is it because the company is folding up or they don't have resources to continue with employment?
The company is not folding up. It's a multinational company, so definitely it's not folding up. But from what he said, they are talking about his level of confidence when dealing with clients. So
Okay.
they wouldn't like to continue with him. Case is halfway through because I'm told the CEO he came with 3 years, and after that, they should have renewed for him. Halfway through, and they've terminated the contract from 20th of September or so.
So they are
No, as to
saying
where
that his performance is not satisfactory.
simply put, yeah, I'll say so.
Okay.
Um,
So your question is you want to find out what this person can do.
what he can do, can he move to a different company? Might be even he said he'd be willing to pay a processing fee if any company accepts to take him on. So I don't know.
Okay.
Either issue
Let's let's
regarding
find
to
let's
the
find out from Lawyer Eunice what the options could be. Lawyer Eunice.
stay on the line, or I can catch it and listen to you.
Well, it's up to you. If you want to stay on the line, that's fine.
I'll stay on the line.
Okay, Lawyer Eunice.
Okay, so there are two different issues here. There's an employment issue and then his subsequent immigration issue. In terms of the employment issue, I am not sure how they came about with the dismissal letter, but obviously they should have had a few warnings, meetings before obviously they dismissed him. In terms of whether he's able to switch to a different company, when it comes to switching under the immigration rules, of course, you are allowed to switch from one company to the other if they are able to grant you a certificate of sponsorship. So if he's gone on to another company and said, "Oh, currently my other employers um, are saying that they are not able to sponsor me anymore, and I'm looking to remain in the UK. Can I obviously work within your company?" If they see him as a fit person for the job at hand and they take him on and they grant him a certificate of sponsorship, then he can go ahead and then switch from his current company to another company. But he would have to find the employment. I don't know how much time he has in terms of them dismissing him, because usually if you have been granted a skilled worker visa, once your work has been terminated, the previous company that has terminated your contract will have to inform the home office that you no longer work for them. So it depends on how soon he has got in terms of getting the other employment and then getting the employment to grant him COS for him to switch to that new employment.
Okay. My friend, are you there? I think he's gone. Let's pick up another one. 0208 493 7345. Hello.
Hello.
Yes. Good afternoon, my brother. How are you?
Good afternoon, my brother. Thank you very much. I'm fine. And you and Auntie Eunice?
We are doing very well.
Great, great. My question is actually different from what you discussed in this
No,
afternoon.
that's fine. That's okay. Please go ahead.
Right. It's in relation to the 10 years route relative to a British child when parents are depending on this, a child who is a British child.
Hmm.
It's about if the child is 18 and he's no longer a child but an adult, but the parents have got 5 more years to actually get to the 10 years for them to be actually granted indefinite. When the child is 18 and the parents have no role to play in the child's life as an adult, what will be the fate of the mother or the family, the parents?
Okay,
Yes,
so in a
Larry.
case in a case where the child, for instance, no longer lives in the family home, maybe
I
the
can
child.
clearly hear Auntie here.
Yeah, if you could listen on your computer or your phone, that would be easier because she's
So you
answering
want me
them.
to go off the line?
If you don't mind, yes.
Okay.
All
In
right.
case I want a follow-up question,
Yeah, you can
I
call
can
back in.
send.
You can call back.
Okay, all right, okay.
Okay. All right. Yes, Larry.
Yes, so in cases where, for instance, the dependent child has now become an adult and is no longer living in the family home, has formed their own independent life, maybe is living away from the mother and is doing things on their own, that would mean that the mother will now have to find another route on which she can apply. It would have been different if the child was in uni. So, for instance, the child has gone to uni, but every time they're on holiday, they'll come home. They still have their GP registered at home, or they still have letters that come through the house because they don't have anywhere else to go apart from coming back home to their parents during the holidays. If that was the situation, then we would say that even though the child is above 18, because they haven't formed an independent life, they can still rely the parent can still rely on that child to be able to make their further leave to remain application. But in this case, he's saying that the child no longer lives at home, and it seems like the child has formed their own independent life. Maybe they're living with friends, or they're living elsewhere which is separate from their mother, and they work probably and earn their own income. So if that is the case, then it means that the mother has to find another route on which she can make her application. If she has another younger child, then maybe that might help, or she may be able to find work just like we are discussing now, or she may be able to say that maybe she's met somebody and the person is British and so she wants to apply on that route instead. So as long as her leave is still valid, she has other options on which she can apply, but she should be sure that the child is obviously living an independent life. Then that means that she hasn't really got much time to decide which other routes are available to her.
0208493745 is the number. You can send a text to 07399208468, and or you can leave your questions, your comments down below in the comment section. We have Kofi Akubia saying that I put in an application for indefinite leave, and there is an urgency to travel to see a very sick sister. How is she able to get the Home Office to expedite her application? Well, there's something very critical that the person needs to attend to, and the application is in, it hasn't been decided on yet. What can the person do to help them expedite it?
To tell you the truth, the only way would have been to pay for priority service. If you didn't pay for priority service, unfortunately, you have to wait the 6 month period unless you are able to show that your sister is in critical condition. So maybe medical evidence to show that this is her current condition, therefore she hasn't really got much time. You need to travel. So if you have medical evidence showing her state or her medical condition, you can use that as a way to expedite the process. But if you are just saying that you have a sick sister who you want to go and see, then unfortunately you wouldn't be able to get that quick of a response. So you need evidence in order to expedite things fast enough.
Yes, we're taking your comments, we're taking your questions and your contributions in the comment section, both on Facebook and YouTube. The next one here says, I want to bring my son and his mother has died. Should I need death certificate to add to this application to bring this child to the UK? Julius is asking, lawyer.
So, yes, if you are making an application for a child to join you here in the UK, the criteria is usually to show that maybe joint parents are here in the UK. If both parents are separate, then it means that you have to show that you have sole responsibility for the child. So you are the main parent responsible for the child. Or that the other parent has passed away, like in this case, and it is now up to you to care for this child. So if you are saying that the other parent has passed away and it's now up to you to care for this child, you have to provide evidence that the mother has passed away by proving the death certificate. And so you need to provide the death certificate as evidence that the mother has passed away. The person looking after the child is only doing so on a temporary basis, and therefore you need to get the child here as soon as possible to be able to continue to care and guide this child through life. And so, yes, you need every evidence, not just evidence that the mother has passed away, but evidence to show that you can maintain the child, evidence to show that you can accommodate the child as well when they come into the UK.
Yes, we're waiting for your comments. Let's get them going through now. Um, Remember also to share the page so others will enjoy that. Okay. Please, can Citizens Advice Bureau help me out with the e-visa application process?
I mean, there are competent people who will be able to help. There are people even in your workplace who can even help you with it. So it's you registering onto the UKVI account. We as a law firm have taken it upon ourselves to help the community in terms of um, registering on the UKVI account. So anyone can help with it. We obviously don't charge for it. And so anybody who you think is a bit conversant with technology, your teenage child can help you, a grown adult or colleague can help you, and we are also here to help you.
Well, BWF solicitors, pop in if you're around the Seven Sisters area, as I keep saying, fourth floor of the Anna House, and they'll be able to help you. Or you can call them on 0208 493 7340. We're live on the community, and the law lawyer is our resource person and guest. What is the earliest period for one to apply for a fee waiver? For example, if a leave expires in March 2025, how soon can the person apply for the waiver?
So, with our fee waiver guidance, they always say that the caseworker is supposed to take reasonable time to consider the request and make a decision as promptly as possible. To tell you the truth, I wish they made decisions as promptly as possible, but unfortunately, they don't. Um, Sometimes we've had to wait almost a year for fee waiver request decisions to come through. And it wasn't so before. Um, Now I think they're having to deal with a lot of backlog, and so it is affecting the time conditions or the time space that they usually make fee waiver applications and then make their decisions. And so if your leave is expiring in March 2025 and you want to make a fee waiver request, I suggest that you do so now. Don't wait till closer to March 2025. Do so now because they are taking much longer to decide on fee waiver requests. So do so as soon as possible.
Well, a stitch in time, they say, saves nine. So do so now, as lawyer has appropriately advised. We have been discussing, does leave and the graduate route count towards indefinite leave to remain on the skilled worker route. Now, Gerald says, if I come to the UK as a skilled care worker in June 2024, lawyer, and can bring my dependents, what if I get my indefinite leave to remain after 5 years? Can I bring them?
Okay, so yes, if you came as a care worker after March of this year and you couldn't bring your dependents with you and you have now been able to obtain indefinite leave to remain or settlement, you can then use your settlement status to bring your children as long as they are under the age of 18. So they must be under the age of 18 to be able to bring them into the UK as your children.
Well, Gerald, yes, that's the answer to your question. So you can. Let's move on to uh, friend on the line 0208 493 7345. Hello.
Hello, good evening.
Good evening, sir.
All right, my name is Champon, and I want to ask a very quick one.
Hmm.
Uh, yeah, so I'm a skilled worker visa, and my the leave to enter visa I came on with expired. It's expiring in September. This just next from tomorrow.
Okay.
So I was able to switch my visa about 4 months ago to a new company,
Okay.
and I brought my then below 18, but now he's 18, who has just been in the UK for about 3 months. And because our old visa has expired, I wanted to extend his visa or switch his visa to my new company.
Okay.
When I applied, they said they wanted me to prove with 3 months bank statement of my support to him. But this boy is also already 18 years with me here. And at the moment, I don't have any bank transactions between the two of us. So I'm a bit stuck in such a situation what I could do.
Okay.
So
So
usually,
the proof that you have been supporting this through your bank is not available.
All right. So I've got the only thing on is that maybe the rent that I pay, but they are saying that I should prove that I support him for the past 3 months through bank statement. But I don't have any direct transactions from my bank to him, like me sending money because he's already here with me in the UK. And I don't send money to him direct through banks or anything. And we stay in the same house. So the only thing I will have maybe will be the rent payment on my bank account. That is all.
Lawyer.
so sorry, do you usually keep receipts of items you purchase or
Oh yes, yes,
so you usually keep receipts? And
yes.
currently, what skilled worker visa are you on?
I'm on a skilled worker visa.
As
In what area?
Currently, I'm around Oxford.
No, no. What I mean is,
So it's a
what
health
kind,
and
what
care.
health and care? Okay.
Yeah, yeah, I'm a nurse.
okay,
Yeah.
okay, okay. So you said you switched to a different company 3 months ago.
Yes, I switched. Yes, so the initial company that I came on with, I have switched from that company to another company, and because my visa was expiring in September, meaning my son's own is also supposed to expire in September. But when I switched, I didn't switch his own because he had a valid BRP at the time.
Okay. So his leave is now expiring, and that's why you are making the switch for him.
Yeah, his own is expiring on the 14th of September. That's why I wanted to switch him back
Okay.
down on my new company or my visa at the moment. Like, yeah.
Okay, because usually if you have valid leave, they are not supposed to check maintenance subsequently. So I'm wondering why they are trying to check um, how you maintain your son. Like you said, maybe it's because he's now turned 18, so they want evidence to show that he's still not living an independent life and he's still at home with you. So if that is the case, then you can provide evidence of your bank statements to show that you pay the rent and the bills, and then evidence of receipts that you have to show that he obviously lives under your roof. So when you go shopping, the receipts are there. If you're buying him clothes and shoes and the whatnot, the receipts are there to
Okay.
show that you are purchasing all those things for him as well. So obviously you can provide all of those, but from now on, please do it by bank transfer.
All right. Thank you.
All right. Thank you very much for your time. Thank you for contributing to the program. Yes, the lines are active and available 0208 493 7345. Or, as we have been doing, we've been picking comments from the comment section on Facebook and YouTube. And you can put yours, announce your presence, and the rest of it. Let's see if we can pick one more. Yes. Eugenia says, "Thank you for your services. If a sponsor for a spousal visa is British, but only has 7 months pay slip, that the applicant still go ahead and apply for the spousal visa and meet the financial requirement? This is because the sponsor was unemployed before."
So they have 7 months pay slip, and then they want to apply for a spousal visa. I'm guessing for somebody who is outside the UK,
I
or is it
suppose.
somebody? um, I'm guessing because if it was within the UK, I could have easily said, okay, then the spouse who is in the UK and the applicant can both combine their pay slips and bank statements to make the application because it's not just centered on the sponsor. But if this is for somebody now coming into the UK, um, as long as they have evidence of 6 months pay slip. So if it's a new employment, they've only worked there for 7 months, as long as they've been able to pass that 6 month criteria, they can provide their 6 months pay slip with recent 6 months bank statements to show that the money is being paid into their account. And then that way, their annual income will be totaled and then they can make the application. So, yes, they can make the application with just 7 months pay slips.
0208 493 7345. Comment section on Facebook at BWF Solicitors. Comment section at BWF Solicitors on YouTube. You can also visit BWTV both on Facebook and YouTube. Grace says, "My cousin had applied through COS, but just to hear that they are investigating the company which issued the cause. Please advise."
Okay. So now she's got the COS, but unfortunately, the company that gave her the COS is being investigated.
Mhm.
Usually, if you hear that, then that means that it is likely that the company will be stripped of their sponsor license. And if that is the case, the Home Office would usually write to all the employees under that company to let them know that the company no longer has a sponsor license and therefore they are giving them at least a period of 60 days to make an application onto a different route if they are able to show that they meet the eligibility requirements of that route. And so they will be informed from the means of communication, which is either email or telephone number that was given when they first made the application as a skilled worker. So if they made the application initially as a skilled worker from outside the UK, they should be looking at the email address that was initially used for the application to receive any updates from the Home Office. If the company is kind enough to tell you that they have been stripped of their sponsor license, then of course you do whatever it takes to secure leave to remain on another route. And so it's better to seek advice to see what options are available. If it means switching on to a different employer who can grant you the COS to be able to continue to work and live in the UK, you do so. Or maybe you have met somebody and therefore you can apply as a partner to a British spouse or a settled person here in the UK. So you may have other routes available to you if the company has been stripped of their sponsor license.
It's the community and the law brought to you by BWF Solicitors. We're taking a break, and when we come back, we take a few of your comments and concerns and questions. Then we'll look at our quiz again and take your answers. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back. Thank you very much for sticking around. We're live on BWTV and it's brought to you by BWF Solicitors, our trusted partners. When it gets to the law, we're taking your comments, we're taking your contributions, we're taking your questions. Gerald comes in and, well, let me also remind you again that we are with lawyer Eunice Champon, partner of BWF Solicitors. Gerald says, if I divorce my EU spouse and retain my right, am I still classified as a family member of an EU member after the divorce?
Yes. So you're a family member who has now retained their right. And so you will still be making application under the EU settlement scheme. And the whole point of them, should I say, having that retention of right status is so that it is not a penalty to the, let's say, the family member or the spouse who is here in the UK if, for instance, things go sour and they no longer have a means to remain here in the UK. So, if, for instance, there has been a divorce or the EU national just got up one day and decided to leave the UK, or the EU national passed away, there should still be a safeguard in place where the EU national family member who is the non-EA national would be able to continue residing here in the UK. And obviously, this is due to a lot of precedent from previous EU cases, and that is why we have the retention of rights. So you will still be making the application under the EU settlement scheme, but you wouldn't have to provide evidence of the EU national, for instance, after your divorce. So, evidence before, when you were a family member, yes, you would have to provide that. But after the divorce, you wouldn't have to provide any evidence from the EEA national.
Well, a couple of them from the comment section, and we will go to our quiz segment. I got my indefinite leave to remain through the 10-year parent route on the 6th of December 2023. In 2024, I was in Ghana for holidays from the 26th of November 2014 and to 28th of December 2014. On what date exactly can I put my application for naturalization? Because I read that there's a requirement that I should have been fiscally present in the UK for 5 years prior to my application.
I wonder what he read because I've never heard such a question before. You can go on holiday. There's nothing wrong with going on holiday and returning to make a naturalization application. So, as long as you are able to show that you are in the UK at the date of the application, you can go ahead and make the application. I think the requirements are that you shouldn't have traveled for more than 450 days within a 5 year period, and you shouldn't have traveled for more than 90 days within the 12-month period before you make your application for naturalization. So, as long as you're in the UK, you can make the application. And I don't think he spent more than 90 days outside of the UK, so he should be fine.
This one says, please, I am applying for indefinite leave to remain FP. I don't meet financial accommodation requirements. There's a friend who has been supporting me financially in the last 2 years. He traveled for 6 months, has just arrived. His bank statement doesn't show any 6 months UK transaction proving that he has spent that amount on me. It only shows his earnings. Can I still use it? Do I have to wait for another 6 months while he is in the UK before I can put in an application? How is annotated statement drafted in relation to bank statement? Like,
Okay, so I'm assuming that this person wants to make a fee waiver request before they make their leave to remain application. Um, Usually, if they were making a fee waiver request, they will need to provide evidence of the financial support they are receiving. So if it's um, the gentleman that has traveled abroad for more than 6 months and has come back, who is providing them financial support, then they have to show by what means this financial support was being provided. Because you have to show bank transfers to be able to show that, yes, this person was looking after you. But if you are saying that he wasn't here for 6 months, then there must have been another means by which you were receiving financial support. So you need to provide evidence from those other people who were supporting you financially. And if those other people were giving you cash in hand, then get them to write a letter with a copy of their ID to say that they were providing you with cash in hand, such as £50 a week or £50 a month, on a monthly basis, and therefore, this is their letter in support of your application. If you are making the application without a fee waiver request, and so you're saying that you are just making an application for further leave to remain, usually they
she
will
answers the
request
question.
that you provide evidence of any work that you're doing. If in that person's case they are not working whatsoever, they have no income, they have been at home for the past 2.5 years, and they have just been receiving financial support from other people, still go ahead and provide a letter from whoever was providing you with financial support with a copy of their ID. And then the person who has been providing accommodation, you can just provide a letter from them with a copy of their ID to say that they were um, obviously good enough to provide you a place to stay whilst living here in the UK. So you can provide letters from all those people and add that to your application. It shouldn't really make any difference if you are not able to provide actual bank statements to prove that you are being financially supported by that person. Of course, if that person has traveled for more than 6 months and there are no transactions in their account, you wouldn't want to provide those bank statements because there are no transactions for 6 months. So you would need evidence from somebody who is in the UK to say that they have provided you with financial support over the past 2 years.
Well, next one says that I come to the UK as a dependent. My main applicant has gone back to Ghana. Okay, I came. Okay, I think I'm getting the gist of it. You came back. It came to the UK as a dependent. Your main or your sponsor has gone back to Ghana. Can it affect the person, lawyer?
So, yes, it can. If you are dependent of the main applicant and the main applicant has decided not to come back to the UK. So I'm assuming that they are trying to say the main applicant is not returning to the UK. If that is the case, then obviously their visa will be affected because come what may, if their visa were to end in December, for instance, and the main applicant wasn't here to extend their leave, then that would mean that their visa as a dependent will expire without any further leave to remain. But if they're smart enough, they may have to seek legal advice and find out if they could switch to other routes without having to depend on the main applicant. So that could be another way of you saying that, okay, what other routes are there for me to apply on if the main applicant is not here in the UK?
Okay. Can we just squeeze in one quick one before we go to our quick segments? Now that you're here, I'm just squeezing your bit. We just have a moment to answer that. In using UK divorce certificate to prove divorce, is only the final order that is used or the final order and conditional order? Could it be one or the other or both?
So the conditional order is a conditional order. It is just to say that the court is giving you some time to see if you can reconvene things before they give you the final order. So your divorce certificate is the final order. It is not the
The
conditional
conditional
order.
order.
So if you're proving your divorce in this country, it is the final order that was granted by the court, not the conditional order.
And obviously, you can't have the final order if you didn't have the conditional order.
Yes, of course. So they would usually grant you the conditional order, and as it says, it's conditional. So it means that things can change. If obviously you decide that you both don't want to go ahead with the divorce, then it will just stay at the conditional order, and that means that you didn't go ahead to apply for the final order because obviously you have to apply for the final order before it is granted. So if you don't apply for the final order, that means that you are still not divorced. So you have to obviously apply for the final order in the time frame that they have given. And then once you receive that, you know that you're a divorced person.
Well, the final segment for this program is up next, and it's this question. There's this application. Barbara Brown is applying to join her husband, Kwekusu, in the UK with two of her dependent children under 18 years. Barbara has been told that her visa fee has come to £13,000 for all three of the children. Kweku is a bus driver and earns £29,000 per annum but has no savings. He tells Baba to apply a loan as they cannot afford the fees. Question is, what must Baba do to prove that she cannot afford the visa fees for all of them? Is it one, she has to swear a statutory declaration to confirm that she cannot afford the fees? Is it two, Baba would have to send her tax clearance evidence? And three, how much income she and Kweku get and how much she has in her savings would have to be shown. Then they need to deduct all the expenses. Think about this, and I'll be taking your answers briefly after this.
Based in London, we are a dynamic award winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, and we're back. Baba Brown's scenario, Kwakusu's scenario, both of them, what do they need to do? What must Baba do to prove that he cannot afford the visa fees for all of them? Charles Emery says number three, show how much income she and Kweku get. Joseph Isia says she has to swear a statutory declaration to confirm that she cannot afford the fees. Simon says, I choose one. Yes. Well, that's your choice. Thank you. James Abam says option number three, show how much income she and Kweku get and how much she has in savings, then deduct all the expenses. James Upon says number two, Baba will have to send her tax clearance. Kujade says three. Thank you, Kojo. Mary Champon, number three, show how much income she and Kweku earn and deduct expenses. Aaron Bunsu says number one. Well, Evelyn Asumadu, number one. Okay, now let's see what the answer would be. Let me go over to Laura Eunice. Unpick them. Let's see what the right answer would be.
Quite a number of people went for number one. I'm just trying to imagine what the thought process was in choosing number one. it says clearly that he earns 29,000 a year, but unfortunately he doesn't have savings. So it is the fees that he has to pay for all three applicants that he's quite worried about, because
Mhm.
if each person is going to cost £5,000, that means that for the three of them it's going to be over £15,000, and he hasn't got any savings to rely on to say that he will be able to manage or pay for the application. And hence he's saying that, okay, he will want to make the application for just his wife, Baba, where we have a human rights application. So human rights based on your family life under Article 8 is a good way to start, because you are saying that these are exceptional circumstances. You want to be able to have your wife and your children here in the UK, because there'll be no one to look after the children if you leave them behind. Because your wife is here, the children are there. It's going to be difficult for anybody to take care of the children whilst your wife is here. So it will be unduly harsh, like we said last week, under Gen 3.1 and 3.2, to let the caseworker go ahead and refuse the application because they don't meet the financial, I mean, they are not able to apply to pay for the IHS and the application fee. In a case like this, once you make a fee waiver request, usually they are supposed to look at the evidences needed to be able to decide whether to grant a fee waiver request for their two other children. So I'm guessing that Baba is able to make the payment, but the two other children would not be able to make the payment. And in assessing whether they are able to afford the fees, so at the beginning we said, are they able to afford the fees? They are going to be looking at their evidences of their income, of their expenses, which will include household expenses and any other essential needs that they have. So, if they're saying that Barbara's income is not sufficient to meet the essential needs of the children, they have to provide evidence of that. And this would usually be by way of bank statements or pay slips to show the income received. Bank statements are likely to show the expenses or the things that the money is being spent on. So they will require both Baba and her husband to provide evidence of their expenses and their income. And if they are both providing their bank statements and they are both providing evidences of their household bills, such as phone bills, light, electricity, water, um, other essential needs, such as shopping and the rest of it, then the caseworker is able to see the fact that their expenses are way too high. There's no way they can save up to um, obviously bring the other family members, because they are supposed to also consider if the couple are able to save enough to pay for the fees. If they are not able to pay for the fees, then it means that they have to look at the fact that because of the essential needs not being met, the home office will have to waive the fee for both children. So let's look at the answers. The answers say she has to swear a statutory declaration to confirm she cannot afford the fees. Just providing a statutory declaration will not suffice, because they need reliable and credible evidence to be able to say that, yes, there's no way you'll be able to afford the fees. So a statutory declaration will not suffice. Number two, Baba would have to have sent her tax clearance. Tax clearance, yes, but it's not a total disclosure of her earnings or her expenses. So that in itself will not be enough. And so the answer is three. Show how much income she and Kweku get in order to be able to provide evidence of her income and her expenses, and his income and his expenses, in order for them to then say there's no way you can afford this fee, and therefore we are waiving off the fees for both the children in terms of the application fee and the immigration health surcharge.
Well, thank you very much, Lawyer Eunice. But we have just about a minute or two to round up. What have we discussed this afternoon? Can you tell us?
Yes, so our main topic for today was to do with anybody who has applied onto the graduate route and then onto the skilled worker route and is thinking, can that 2 years that I have on the graduate route help me in accumulating my 5 years qualifying continuous residence on the skilled worker route? And the answer is no, because the graduate route does not lead to settlement. And the skilled worker route is a route on its own, where you would have to accumulate 5 years of continuous residence to be able to reside here in the UK and then apply for settlement or indefinite leave to remain. And as a skilled worker, whether you are on the global talent route, on the innovator founder route, minister of religion, or any of the work routes, if you have accumulated 5 years of lawful residence under the skilled worker route, you can apply for indefinite leave to remain, having met the knowledge of life in the UK, which is the life in the UK test, and then also the sponsorship and the salary requirements. So you should be able to show that you are still being sponsored by the employer and you are still meeting the salary requirements that are needed to make the application. So if you have met the eligibility requirements and you are able to show that you have remained here for a continuous period of 5 years, you will be granted indefinite leave or settlement under the skilled worker route. Unfortunately, the route will not lead to the 5 years qualification. But if, for instance, you had a graduate route, you came onto the skilled worker route, things didn't work out on the skilled worker route, maybe you jumped off the skilled worker route to apply for a student visa again, and you have totaled a total of 10 years, then you would be able to make an application for settlement or indefinite leave to remain under the long residence appendix. Strictly speaking, for those who are under the skilled worker route, only 5 years under the skilled worker route will qualify you for indefinite leave to remain. So that's it in a nutshell.
And that helps us to draw the curtains down on today's edition of the community and the law. It's often said that because we're going to have a repeat of the meal session, strangers are always very happy to come to dinner. So we'll be inviting you to come to dinner again, same time next week, for another edition of the community and the law. Where we'll bring you another very insightful discussion that will be brought to you again by BWF Solicitors Right on BWTV. My name is Oruku Frimpong. Thank you very much, Lawyer Eunice, for your time and the share of knowledge. And to all my brothers and sisters and the family at BWF Solicitors here in the UK and back home in Ghana, I want to say thank you for your contribution, the research, the advice, and the admin that you put behind this program. We really appreciate that. To Sheila Ankara and Padmo Dudu for doing the aesthetics and the other bits of the admin work and producing the program. To my studio director, Professor Ade, and to you out there, thank you so very much. Have a good evening.